Hello and welcome to SBK Unplugged, Sheldon Bosley Knight's Land and Property Podcast. My name is Kate Gould and I'm the host of the show. Today I am in the studio with our Lettings Director, Rebecca Dean. Hello, Rebecca. Before we kick off, I would like to say a big thank you again to our friends at Mill Street for hosting us in their studio. So thank you very much for having us again, guys. So, Becca, here we are again. This time, we're not talking about Renters' Rights Bill, we're talking about the Renters' Rights Act,
Yes.
as it has just been given royal assent. So I thought it would be a good opportunity for you to just run through a few of the key elements, but also for landlords not to panic immediately, because we have as yet been given no implementation date. So I suppose at the moment, things are pretty much as they were the day before it got given royal assent.
Obviously it's an important update. It's we've been waiting for the bill to become an act. It is now in the statute book. It is now law. But for landlords and for tenants, nothing changes immediately. So I think that is important to note, because I think as soon as you hear that it is now law, and there is, some press which is saying that, certain elements of the Act will be immediate. Well, naturally, you would think immediate is right now, but there are no changes immediately. Implementation dates are yet to be announced, and that will be the next lot of information that we'll be waiting to receive. There is still suggestion that 6 months should be a period that we're given to be able to get everything in place to allow a smooth and seamless process. Whether we get that 6 months, I guess time will tell, and I'm sure it will be within the next few weeks that we'll hear more. But for today, everything is as it was. Section 21s can still be used at the moment. Fixed term tenancies can still be created at the moment. But those are the first two things that we believe will be changing pretty much immediately once we've got those implementation dates.
Because those were the two headline grabbers throughout this whole process, and the government gave everybody to understand that once it became law, that was actually going to happen, and immediate, yeah. You'd be on a sort of periodic tenancy and you couldn't use a Section 21. What are the other key elements do you think that are likely to be implemented? Because we gather that it's going to be implemented in stages. So there are certain elements of the bill that will be done fairly quickly and first, second, third, and then some things that will maybe happen maybe next year. So what is your sense?
Yes, I think the first two that we are expecting will be the abolishment of the Section 21 and the ban on fixed term tenancies, because those have been the two, big headlines really that have been pushed for, and I think have pretty much led this all the way through at the moment. So I do think that those will be the first two things that we see change, and implementation dates. I mean, I don't know when they will be, but I expect that they will be the first two parts of the bill that will be, well, the Act now, sorry. Yeah. Get used to saying Renters' Right Act now. I think those will be the first two parts that we will have to get on board with and make changes to protect our landlords, and obviously have everything in place for tenants as well. Other key areas will be tenants will have the right to request a pet. That's tenants that are currently in situ. There will be a ban on rent in advance. So that's rent more than 1 month in advance. A ban on bidding wars. So the advertised rent will be the rent that the landlord will be able to achieve, and nothing more than that. So, we sometimes have situations where there might be more than one applicant, and one might bid more on the rent to be able to secure the property. It might be that somebody has a pet and they offer a higher rent to the landlord to be able to take the pet into the property. That will not be allowed anymore. So the advertised rent will be the maximum rent that the landlord will be able to achieve.
And I suppose for the pet issue, that's going to be quite important, because at the moment there isn't really any insurance for landlords, tenants regarding bringing their pet in, is there?
No.
So, not having a sort of ability to maybe charge a tenant a little bit more to bring the pet in, that's going to be sort of a consideration, isn't it?
Yeah, definitely. I mean, throughout different stages of the Renters' Rights Bill going through Parliament, I mean, initially there was a suggestion that landlords may be able to get an insurance themselves for the tenant's pet. Obviously, now it turns out that that's not the case, and there isn't actually an insurance that would cover the landlord for that. Then there was a suggestion that they may be able to request a higher deposit, but it seems that that's now off the cards, and it is, still 1 month's rent in advance at the rent that the property has been advertised at as a maximum, and then the 5-week deposit, and there will be no additional security there for landlords, unfortunately. Yeah. It is as we understand it to be at the moment.
And as well as that, the other, I suppose, key element is that a landlord would not be able to raise the rent except for, yearly.
So the landlord, it will be annual increases. Yeah. So, at the moment you could have a fixed term, and it might be agreed that after 6 months the rent is going to increase, or if that fixed term is only for 6 months, it can then be reviewed after that period. But moving forward, there won't be the fixed term. It will be a statutory periodic tenancy from day one, and annual reviews only is what's been suggested in terms of rent increases. And then those rent increases need to be made by giving the tenant 2 months' notice, as opposed to the 1 month's notice that we need to provide at the moment.
Yeah.
And then the tenants will, of course, have the right to appeal to a first-tier tribunal if they don't agree with the rent increase that's being implemented.
So those are the sort of key ones that you are sort of expecting implementation first, but there are others that may come a bit later. So what are the ones that you think that will happen a bit further down the line?
Well, there are others. So there's the Decent Home Standards that's going to be brought in, which will be under Awab's law. And we've also got...
So the EPC regulations as well.
So EPC regulations are going to be 2028. To my knowledge, they don't form part of the Renters' Right Act, but that will be in addition to in a couple of years' time. So yes, something else that landlords will also have to tackle. But the other key element of the Act that is due to be implemented at a later date, we believe, is the National Landlord Register. So every landlord and their property will have to be registered on a portal, which will help landlords and tenants to better see information on the property, the compliance, the history, and I expect will help us as agents as well as we move forward with that.
Yeah. I think one of the key things that I picked up at our recent landlord and investor evening was certainly the abolition of Section 21, and a lot of landlords, I got the impression, were a little concerned, thinking that if the government were to get rid of the abolition of Section 21, that there would be no ability then to ask a tenant to leave for any reason, but that's not the case, is there? So landlords will still be able to... No. If there is a breach of tenancy.
Yeah, absolutely. And I think that has been a general concern for landlords when you hear abolishment of Section 21, end of no-fault evictions. I mean, that was a big message from Labour when I think it was when the bill went into its second reading with the Lords. I recall seeing that message that no-fault evictions will be banned. Well, that's not the case. I mean, yes, landlords will still be able to apply for vacant possession if there is a breach of tenancy, and that will be done through the normal proceedings that we follow at the moment anyway, so under the Section 8 notice with the relevant grounds that need to be used. But what will also form part of that Section 8 notice is the Ground 1 and the Ground 1A, which will be grounds for landlords to use if they either wish to take the property back to sell it, put it on the market for sale, or if they wish to take the property back to move into it. So the Ground 1 under the Section 8 already exists. So if a landlord does wish to take the property back to move into it, that's a ground that could be used at the moment anyway. However, most landlords, if they do want to take the property back because they want to move back in, they would normally use a Section 21 notice, and in most cases be successful with that. So that ground 1 is already there, but the new ground 1A will allow the landlord to ask the tenant to vacate, to be able to put the property on the market for sale. So obviously Section 21 is 2 months notice. Section 21 can be served, it can end after a 6-month period, whereas the new grounds under the Section 8 that will be used will be 4 months notice, and my understanding is that they can't end before the first 12 months of that tenancy being in place. So although when the initial tenancy starts, it will no longer be a fixed term. The tenants could move in and give 2 months notice at any stage. We're waiting again for clarity on whether that will be in line with their rent period, as currently a statutory periodic would have notice in line with the rent period. So we're expecting that will be carried over with this new piece of legislation. But for a landlord, the tenancy will have to run for a minimum of 12 months before any notice can expire, if they're looking to either sell or move back into the property. Breach of tenancy, obviously something completely different. They're not expected to wait that time frame if there is a breach. So non-payment of rent, antisocial behaviour, just general breaches of the contract in terms of how the tenants might be looking after the property. All of those will still be reasons to be able to serve the Section 8 notice with the relevant grounds, which will hopefully give the landlord vacant possession as soon as possible. But obviously, again, we know the courts are overrun. We know there's still a backlog, and some of the areas that we are working within, that isn't really getting any better. So it will be interesting to see how that's going to be managed as well.
So for you and your teams now, I mean, you've been very proactive, sort of ensuring that your teams are well versed in everything as it's been going along through the Commons, through the Lords, and now on the statute books. But what is this all going to mean for you and your teams, and also by association for our landlords and their tenants?
I think for us at the moment, it will be to be continuing to do what we have already been doing during this year, and even prior to that, we offer a service to our landlords. We want to be able to keep them informed. We want to educate them. We want to make sure that they're protected. A lot of the work that we've been doing this year is around what we've been hearing about the Renters' Right Act, but when it was a bill. And making preparations in the best way that we can, but that's been mainly through giving advice, providing updates, making sure that the teams are in a position where they can answer our landlords' questions. It's really, really important. So, for me, in my role, it has been about landlord updates, these podcasts, our landlord and investors evenings. We had our first one in Stratford in September. We've got our next one in the Leicestershire area in just 3 weeks. So 3 weeks today, the 18th of November. And we're doing those things so that we are talking to our landlords and making sure that they're kept informed, making sure they know what we're dealing with at the moment, making sure they know what's to come. And those are all really, really important parts of that service, in my opinion. I'm also keen to get to the landlords that are not currently with Sheldon Bosley Knight, because those are the landlords that may not be getting updates elsewhere. We have been receiving some information from some of our landlords about other agents that they work with, and we are being told that the information is just not there. So I am keen to get to those landlords as well who may not be getting the updates from their agents that we hope that they would be. Other work then that we've been doing is around the protection of landlords. So how can they protect themselves and their portfolio in the best possible way? Rent guarantee. Can we ever do a podcast without mentioning rent guarantee? But rent guarantee and legal expenses cover, I think, is just massively, massively important for landlords. And that's only going to be even more important as we move forward. Making sure there is a cover in place to cover any rent arrears, but more importantly, the legal expenses side of that cover. So as you know, and all of our landlords will know, we work with HomeLet, who offer up to 15 months of rental payments and up to £100,000 worth of legal expenses cover. So if a landlord needs to get vacant possession, if a tenant is in breach of contract, if the rent isn't paid, the rent will be paid. If it's a breach in another way and they've got to go through the court to get vacant possession, that cover is there through HomeLet. We've also then introduced a deposit alternative. So we partnered with Flatfare earlier this year, and that was again with the landlord's protection as the number one priority, to make sure that they're in a position where they can get better protection on their property or their portfolio. It is something that the tenants have to choose to have and pay for, but the landlord has to opt in to that service. But that's something then that gives the landlord up to 10 weeks of cover for damages and dilapidations at the end of the tenancy, rather than just the 5 weeks that you get through a traditional deposit. So those are the two main things that we've implemented this year, but we have done that to make sure that the landlords are protected and they have the ultimate peace of mind. I think landlords, especially without rent guarantee, could find themselves in real trouble. Other things that we've been doing, sorry, did you have a question on that?
Well,
then?
I was going to say that we do have some sort of let-only landlords, don't we? And there are, as you mentioned earlier, there are going to be some landlords who are self-managing. It's going to be really important for them, because this piece of legislation that's gone through is huge, huge.
Yeah, absolutely.
And, a lot of landlords, some of them are accidental in that they maybe just have one or two properties and they have a day job as well. So being able to take them under your wing, if you like, and give them the tools they need and to support them is going to be really important. And they are going to need the support of a really good agent, aren't they?
Absolutely. And, we've talked around this before as well in previous podcasts. Your typical landlord is the you and I. I think there is this general perception that landlords are, just they've got a huge portfolio, they've got lots of money, lots of spare time, and that's just not the typical landlord that we're dealing with. We deal with a lot of accidental landlords who are in a situation where they've had to let their home to be able to upsize or downsize, or because work's moving overseas or just changing location. And then we've got the individual landlord who just wants to invest in one property for a future pension or for the children when they get older. So there are lots of different scenarios and different landlords that we deal with, but the majority are not big portfolio landlords. They are landlords that have one or two properties, and that landlord is likely to have a job, a family, general day-to-day to deal with, like we all do. So putting the time into looking after either one property or 10 properties, it's going to be consuming, especially with this new act. Looking at that new piece of legislation in addition to the legislation that is already in place, and making sure that you are fully compliant as a landlord, ticking all of the boxes, building a relationship with your tenant, keeping two-way communication, I think is really, really important if you're a landlord that's self-managing. I guess a lot of landlords wouldn't want a relationship with a tenant where they could say they've got a friendship, because they probably want to keep that line there between what would be a personal relationship and a professional relationship. But I think it's massively important that any landlord that is self-managing has got a relationship with their tenant, so they've got an open communication stream. They can go and visit the property to check that all is being kept in good order. They can rely on the tenant to report maintenance issues to them. They can rely on the tenant to let them know if there might be a problem with the rent, but they also feel confident enough in picking up the phone to talk to the tenant about their rent if for some reason it isn't paid, because those are all the additional duties that a landlord has when they are self-managing. And that comes in addition to your general compliance, making sure your gas safety is renewed, your EICR is renewed, if there's any works that come from those certificates or any works that are reported, sourcing contractors to go to the property and put things right. So there is a lot for landlords at the moment, and I think my advice to any self-managing landlord, even before this act, would be to speak to a good agent, and speak to a good agent that has got all of the information and that is advising you and keeping you up to date with what's to come.
Yeah, 100%. And that's what you and your teams have been doing this year. Well, and beyond, but particularly this year as the bill has been going through.
Yeah, absolutely. So, I mean, we've already touched on, obviously, some of the updates that we've been doing. So, the updates we've been doing have been every 2 to 3 weeks. We've obviously been recording our podcast. We've had a lot of social media content. We've held our first landlord and investor evening. We're approaching now our second one. And we want to encourage our landlords to pick up the phone and talk to us. If they hear something and they're not sure about it, or they've got a concern, we want to be talking to our landlords. We hope that the emails and the videos that we send out, they do get watched, listened to, read, because we're sharing that information because we consider it to be important. You know, we don't want to be flooding landlords' inboxes with big, long, lengthy emails that they might not read. And actually, I had a couple of landlords that openly spoke to me at our Stratford landlord evening and said, "Oh, you're the lady that's been sending me a lot of emails. Oh, I have to say, I've not watched some of the videos," but actually then approached me at the end and said, "I'll definitely be watching your videos now after that update, because I think it was just a real eye opener over what's to come." And I hope that there are more landlords that do open the emails and watch the videos than those that don't. But you know, we don't want to just be spamming people, but we want our landlords to know that the information that we're sending out is valuable. Yeah. And by trying to do it in video content, it's short 2 to 3 minute videos with a brief update, which should be enough for them to understand what's going on, understand what's to come. But you know, it's not.
It's easily digestible.
It's not taking up a lot of their time. You know, you can pop it on in the car or on your earphones while you're out on your dog walk. And it's just a quick update rather than having to sit and read a really long email and then digest that information. So so there's all of those updates, and then in addition, we've just been listening to what we may need to do as agents to, you know, protect our landlords and to be ready. So the Section 13 process, we've already implemented that. I mean, the rent increases are still with 1 month's notice at the moment, because that's all that needs to be provided. But the way in which we do them, we have already, you know, adapted to what is to come. You know, when it comes to fixed terms coming to an end, we're being open and honest with landlords. Some landlords just really want that security of a fixed term tenancy, but interestingly, some tenants do as well.
I was going to say, some tenants surely must want, you know, if they're coming over to a region for work or a sort of family thing, that they might need that assurance that they can have that property for 9 months, for example. A lot of tenants will say that they want to renew, so they know they've got the security for another 6 or 12 months in the property. So given that that's not going to be able to continue, we have been being honest with landlords in, you know, we can renew the tenancy for you, we can do another 6 month or 12 month or 24-month fixed term. However, when this bill becomes an act and then there are implementation dates and the law actually changes, that tenancy that you have paid to renew is automatically going to become a statutory periodic. So, you know, you may have 2 months of that tenancy left, you may have 12 months of that tenancy left. But it's about allowing the landlord to make that informed decision with all of the information that they have to hand. So so that's something else that we've been working on. I mean, pets, we've not really had too much around that at the moment in terms of tenants coming forward and requesting pets. We don't seem to have had a flurry with that, and tenants do request pets anyway, you know, and those requests do go forward to landlords. So I don't really see that changing too much. I think it's more that with the Renters' Right Act, the tenant has the right to request. Whereas at the moment they may feel like they don't, and they may feel like, you know, the tenancy is as the tenancy is. But generally, if our tenants do want to have a pet in the property, they will make that request anyway through their local branch or with their landlord directly if it's not managed by Sheldon Bosley Knight. Yeah, and I suppose for the pet issue, landlords still have an opportunity to say, I don't think having a dog on the 10th floor of a block of flats is a good idea, and they can refuse sort of
Yeah,
reasonably,
so, I mean,
can't they?
Yeah, so it's being said that there will be, reasonable grounds on which a landlord can refuse. So, if they have got a flat or an apartment, it's likely to be leasehold, and it would normally be in the terms of the lease that a pet can't be kept in the property. Obviously, it's also the definition of pet. A pet could be a hamster in a cage, or it could be a giant Alsatian, couldn't it?
Or
I don't have a
horse.
preference to one or the other. But, it's very different. Can I have a rabbit in the garden for my child, or can I have, a couple of cats that are going to be kept inside the property? So it is very different. They come in all shapes and sizes. But I think it is just that the definition of, the right to request a pet.
Yeah.
But if it is in the lease that a landlord can't accept a pet, then that will be a reasonable reason to decline. My understanding is that landlords will also have the right to refuse if they feel that the property isn't suitable, but can also demonstrate that. So, if it's a small cluster house that doesn't have a garden and they want a dog, well, where is that dog going to go outside? I think, it's about assessing the space as well. As you've just mentioned, the 10th floor apartment, that's a lot of stairs for a dog, or some very high windows for a cat to be getting outside.
Exactly.
So but I'm not sure that's going to create too much of a headache for our landlords. I think it's just about, again, receiving the request at the moment. The way that it has to be done is in writing with a description of the pet. We'll be able to put that forward to the landlord, and then obviously it would be our duty as the managing agent when we do our interim property visits to make sure that is the pet that has been requested, and that it's one pet, not three.
Yes.
And it is a Jack Russell, not a Rottweiler, so it would just be about making sure that all is then in order as per the request of the tenant.
Excellent.
Okay,
so there's still a little bit of uncertainty, but we're hoping for information to be coming out of the government fairly soon in terms of dates.
I think there will continue to be uncertainty until implementation dates and exactly what that looks like and what needs to be done in readiness is announced, and we can then share that with our landlords. Some of the questions that I got at our recent landlord and investor evening does show that I think there is a general fear, but there is also a lack of understanding as well in some areas. So as soon as we're in receipt of any information, we will be sharing that with our landlords, and in a way that we hope that we can just get the message across as simply as possible, so that landlords do understand. We're here to obviously answer any questions. We are running our next landlord and investor evening on the 18th of November, which I have already mentioned twice, but I just want to get that in there again. 18th of November in the Leicestershire area, 6 p.m. start. All of our landlords are invited, and even if you're not a landlord at the moment and you want to come along, then you are welcome to. But hopefully that will be an evening that will leave landlords in a position where those that attend, where they're feeling a bit more confident about things. But for now, we will just continue to wait for the information, share it as and when it's available. And I think we just hope now that, the government do manage this and listen. I think is going to be the important thing. There has been suggestion that they will now have to listen to the meaningful conversations and have an understanding from landlords, so that we don't damage the private rental sector. The idea of this bill was to make things better. I still keep calling it a bill, but the idea was to make things better. So we don't want to be in a position where we've got a bigger problem with landlords exiting, no longer wanting to be a landlord, new landlord choosing against entering the private rented sector. I think it is about making sure that we've still got the stock to meet the demand, which has already been a challenge over the recent years.
Well, I was going to say that, even just last week I was reading some of the trade press, and although the stock, the supply-demand imbalance is easing somewhat, it's still, way too many tenants looking for too few properties. And if landlords do feel that they are unable or unwilling to stick with the sector, that they will leave, and then tenants could face homelessness, which is completely not what was intended with this bill act. So the government, as you say, has to listen, because otherwise we will be in a much more difficult, tricky situation in which to navigate.
Well, the lack of stock in recent years is one of those things that has, not allowed tenants to be able to move on when a notice has been served.
Yeah.
Especially if it's a family, for example, trying to then find a family home that meets the needs and also the size of the family, perhaps. Just a typical example. If they've got children in schools, or they need to be in a certain location, if the stock isn't there, it's very difficult then for people to move on. So what we don't want to see is that then becomes an even bigger problem, because naturally less stock generally means increased rents. Increased rents obviously make it less affordable to tenants and do cause potential financial difficulties, and that's in addition to the homelessness problem. If tenants are not able to secure a property, partly because there's not enough stock available, but partly because rents are too high. So yes, there definitely needs to be some listening, some monitoring, and I'm hoping, from press releases that I've read in the last 12 hours, it's that tends to be the general message, is that will happen. So I'm just hoping that it will, so that there isn't damage that's created to the sector here, and we can only see it as an improvement going forward.
Yeah. And in the meantime, for our landlords, just to keep you in mind and pick up the phone, pop into the office if they have any kind of question at all relating to this act, and what it might mean for them, no matter what sort of question it is. You're quite happy to answer anything, aren't you?
Absolutely, yeah. I will be happy to speak to any of our landlords, or landlords in general, myself. We've got very good and experienced lettings managers in all of our branches, and then they've got experienced and knowledgeable teams as well, and we will continue to share the information and the knowledge with the staff, so that they're also up to speed with what's happening. But yes, we've got offices over Warwickshire, Leicestershire, touching on Worcestershire with our Evesham and Pershore branches. And yeah, if you're a current landlord, you'll know who your point of contact is. If you're a tenant find landlord and you want to consider a fully managed service and want to know more about what that looks like, please contact your lettings manager in the branch, and they will gladly have a conversation with you. And if you're not a landlord with us already, but you would like to talk to us, like to know more, and perhaps want to know what our services look like, then again, we'd love to hear from you.
Yeah, doors are always open.
Absolutely.
Brilliant. Well, Becca, thank you so much for coming in again.
No, thank you. It's good to be here, and obviously it's a really important topic, and one that we will continue to update on as and when we've got more information.
Brilliant. Thank you so much for coming in, and thank you so much for watching, and we will see you again next time. Thank you very much.